All righty. Welcome to this cool afternoon, everyone, and thank you for sharing your afternoon and early evening with us on behalf of the Area Agency on Aging and Credit Union. We are very excited to have you join us as we are going into our third session of our 7th annual Pikes Peak retirement series. My name is Pamela, and I represent the Area Agency on Aging, and the staff person, we have another staff person behind the scenes. Her name is Jessica McMullen, and she is our policy and communications manager. She's responsible for the webinars to make sure they run smoothly. This year, you're going to find it's a little bit different, the series that we're doing this year. We expanded the bandwidth for the entire state of Colorado so that the resources that are available with all of the webinars have been available, whether you live in Colorado Springs or Denver or Fort Collins. They are on our website at ppacg.org/events, and we hope that you take advantage of those. Also, this year, we are expanding, as I said, to the full state, and we did that through the help of the Colorado Bar Association, the Colorado Area Agencies on Aging, and our state health insurance programs located throughout Colorado. The Area Agency on Aging, which probably many of you are familiar with, we have about 16 in the state of Colorado, and we are responsible for comprehensive senior information, resources, assistance, and public education for adults 60 and over. We're also very proud to house the local state health insurance program, commonly and fondly known as SHIP, where we provide objective Medicare and health insurance information. Please keep your microphones off at this time, and we will have questions at the end. We will do the chat at the end. We will have a survey later, and I will let our ENT representative tell you more about that. I didn't want to neglect introducing Katie Griffin, who is the Community Education Coordinator at ENT Credit Union, and she's going to say a few words about ENT and our partnership and the survey and the little magic that comes with the survey this year. So Katie, if you'd like to go ahead and take over, that'd be great.
All right, thank you so much, Pam. I appreciate that. Yeah, so I'm Katie with ENT Credit Union, and we are Colorado's largest credit union with over 40 convenient locations located along the Front Range. Founded in 1957, we are a not-for-profit organization with a commitment to improving our members' financial quality of life. And we're so proud to partner with the Area Agency on Aging to offer these courses, and also excited, as Pamela hinted at with the survey, excited to let you know that you will have a chance to win a $50 Amazon gift card just for attending today's session. So be on the lookout for that survey. You'll be receiving that in your email from Jessica. And once you complete that, you'll be entered to win that gift card. And we just appreciate all of y'all for being here today. Thank you so much.
Thank you, Katie. Appreciate that. We are so honored to have ENT Credit Union as our partner for these last 7 years, and we would not be experiencing nearly as much success for our program if it had not been for their collaboration and their partnership. So we are very grateful for that. So this time, I would like to introduce our main presentation, Skip Morgan, who is attorney at law with Morgan Legal Offices, PC. Skip specializes in wills, trusts, estate planning, probate, protective proceedings, and military law. In addition, he's been the past chair of El Paso County Bar Probate Section and the Christian Legal Society. He was also one of the 3 main speakers at Senior Law Day just last Saturday over there at the Senior Center. So without further ado, please join me in welcoming Skip. Skip, it's all yours.
Thank you, Pamela. I appreciate that. For those of you, if there was anybody here who was at the presentation at Senior Law Day last Saturday, go get yourself a sandwich, because this is the same thing. It's pretty much sort of a standard. My idea is to redeem the reputation of the 2% of all lawyers that the 98% give a bad name to. And to that end, I want to tell you a very personal story about, about a lawyer and a physician and a priest. And the three of us, when I was a judge advocate, we had a dear friend who was unfortunately suffering from a terminal illness. And he knew he had not long to live. He had no family to speak of. And so he gathered his three closest friends, and that would be, the priest and his doctor and his lawyer, which should tell you something about his taste in friends. But he gathered us together and he said, I'm going to do something that they say cannot be done. I'm going to take it with me. And he says, with that in mind, I have withdrawn $50,000, a total of $150,000. And I'm giving each one of you an envelope with the full $50,000 in cash in it. When I pass, there will be an open casket, and I want each one of you, as you pass, to slip your envelope in the casket with me. I'm going to take it with me. Now, I want you all to promise that you will do that. And so we all did. Well, unfortunately, he did pass, and we did go past, and I noticed that the priest slid in an envelope, and the doctor slid in an envelope, and of course I did. But when it was over at the wake, the man was Irish. The priest kind of broke down a little bit, and he said, I need to make a confession to you two. He said, I promised that I would give him back or the full $50,000. But he said a terrible hailstorm hit the parish, as such things do in Colorado Springs. And the roof was damaged, and we just didn't have enough money in the building fund to take care of it. And he said, so I took out $10,000 to pay for the parish roof. The deceased was always a very generous patron of the church, and I'm sure that he would approve of me doing that. The doctor said, well, I'm glad you said that, Father, because I've got a confession to make as well. He said, after he gave us the money, I had it, and a 9-year-old boy presented with a very rare case of cancer. The boy was from an indigent family. They had no insurance, but it was surgery that we could do and that would save his life. And he said, I admit I took $25,000 out of the envelope and used it for that boy's surgery. And I hope that he would approve of saving a life that way. Well, I was frankly disappointed. And I told him that. I said, regardless of how noble your motives were, the fact of the matter is you promised that you would put the full $50,000 back in, and neither of you did it. I, on the other hand, wrote a check for the full $50,000 and slipped it in that envelope and put it in his casket with him. So that just goes to show you the honesty of lawyers. How he negotiates the check, I guess, is his problem. Okay. That's a lawyer going for the last dollar. What am I doing today? Actually, well, I'm going to give you 4 tickets to what I refer to as a lawyer-free retirement. And one size does not fit all in this or in anything else, but estate planning is particularly important that it be personalized. When you see the advertisements for these seminars and they talk about selling you a living trust or something like that, there is a presumption that a trust is the right thing for you. And the reality is, in many of these situations, is kind of a mass-produced sort of a thing where some names are filled in, but pretty much it's boilerplate, and you get an 1.5 inch thick notebook. It's kind of similar to the situation where I would, if you were actually attending a Pikes Peak Area Council on Aging dental hygiene seminar. And I told you that you may not know it, but every one of you needs a root canal. And root canals are expensive. They're normally around $3,500, $4,000. But outside of the room right now, we have a dentist all set up. And today only, there will be a root canal available for each one of you for just $1,500. Well, you'd laugh me out. You wouldn't listen to me, because of course I can't know that everybody needs a root canal, or even that anybody does. So in the same fashion, you have to be cautious about doing something that is not really something tailored to you and your interest. So the first ticket, though, having said that no one size doesn't fit all, I'm going to tell you that everybody needs a will. And you need to make it and to keep it up to date. Why? Well, first of all, it's to transfer property to the people you want to transfer it to. Without a will, your property is going to be controlled by the state laws of intestacy. And that can result in some very unusual or some undesirable kinds of results. So you don't want to send or give your estate that you've spent all your life accumulating to the wrong people. And who are the wrong people? Well, I'm going to suggest that most of you know the answer to that one. Oh, this was the local bar meeting recently. The first one is the tax collector. None of us want to have our estates decreased by tax. Now, in that respect, I have some very good news and some potentially bad news, but we'll cover that in a minute. But for the time being, we do know that we don't want our estates to be decremented by taxes if we can avoid it. The second one I think we can all agree on is we don't want lawyers to be getting a lion's share of our estate. And there's ways to make sure that that doesn't happen, and we're going to discuss those. And finally, just what I refer to as assorted creeps who are not on your Christmas card list. And this could be stepchildren, it could be exes, it could be in-laws, all sorts of people like that. And the way you prevent that from happening is that you have a will that specifies where you want things to go. Now, when I say things to go, as I'm going to discuss in a few minutes, a will covers all of your so-called probate assets. And probate assets, as again, I will explain a little bit more, but Colorado has a really terrific probate code. And by terrific, I mean user-friendly, inexpensive, and very, very flexible. Colorado allows you to do something like a personal property memorandum. You may have family heirlooms, firearms, antiques, jewelry that you want to go to a certain person. And you don't want to list all of that in your will because that would take a long time and it might change over time. So Colorado lets you say in your will, I am going to have a personal property memorandum. And that will list items of tangible personal property that I want to go to specific individuals. Then, just by having that paragraph in your will, you can keep this personal property memorandum on scratch paper if you want to do it that way. It doesn't have to be witnessed. It doesn't have to be notarized every time you change it. You can keep it up to date as in a Word document, just so long as it's clear that it's something you want to do. And that's a very, very handy thing to do because kids will fight over the darndest things. It is true that particularly upon the death of the surviving parent for a family, that suddenly things that didn't seem like they would be that important suddenly become very important because it's a piece of mom or dad. It's a family Bible. It's a portrait of an ancestor. It's a photo album. It's something that is emotionally valuable, even if it isn't otherwise. And I use the example, true story of a pair of brothers who spent somewhere in the neighborhood of $30,000 fighting over Mattel Hot Wheels. That's just how silly it can become. So by anticipating the things that are important that may have value to your children or to your heirs, you can really save a lot of problems. Because if you don't specify this, let us say, and I always have this kind of visual aid here. This is a A26. It's hand carved. It's a wooden model. It's a model of the A26 my father flew in Korea. He won the Silver Star in that. It's not particularly valuable. It's kind of an interesting piece of art or craft, but it's priceless to me. And it wouldn't look good sawed into two pieces, one each for my sister and for me. And so that's the kind of thing that you want to identify. And when you do that, you will have saved your personal representative, who for most families, not all, is one or the other of the adult children, from having to MC a family feud where the personal representative can find herself as a contestant, as a referee, and ultimately as the judge, if you're fighting over one particular thing. So having that list takes a tremendous burden off of whoever's going to be your personal representative, and I can't recommend it strongly enough. And the kids may say, oh, Dad, this is so morbid. I don't like to think about this. There's nothing you want that you have that we want. Nonsense. There is something. And it's important for you to have one of those family discussions with kids and find out if there are some things that are particularly valuable, and then put that down in your personal property memorandum. It's another good way to keep heirlooms in the family. Sometimes mom may have some very valuable jewelry that may have been in the family for generations. And sometimes that same family won't have any boys, but they want somebody within the family to take. And so maybe nieces will find themselves keeping family heirlooms such as jewelry. And you can keep them so they don't have to get sold. Okay, the second tip about wills, and I'm sorry, I'm going to get a little bit technical here, but you need to harmonize probate and non-probate assets. Why do I say that? First, this is important. Your will only controls probate assets. That is to say, things that were in your name alone at your death. If you have things in a joint tenancy, if you have IRAs or 401ks where there is a beneficiary designation, or if you have transfer or payable on death bank accounts, those will go to whoever you designate as the beneficiary, and they will not count against the share of that beneficiary. So to give you an example, I have 5 kids. If I were to say everything to my wife in equal shares, and then to the children in equal shares, so that each one of them would get a fifth. But I have a payable on death account for my daughter, Danielle. She will take that payable on death account and it will not count towards her 1/5 share. Too often, unfortunately, and meaning no offense to Ant and others, but people open up a bank account and they are counseled by the teller or whomever, hey, you know what? If you put this into a beneficiary designation, you'll avoid probate. Well, the answer is no, you probably won't avoid probate, but what you will create is an inequality in your estate that you did not intend. I had a case where a woman with not very large estate, I think it was $30,000 or $40,000, And she had 3 children. She had one son who was of age, he was 22 or something like that. And then she had 2 minor daughters, one of whom was just in I think, junior high school. So she unfortunately came down with cancer, and she put everything in a payable on death account for the benefit of her son, so she could avoid probate, and with the idea that her son would then split it among and take care of his younger sisters. Well, unfortunately, when she died, he did nothing of the sort. He just took the $30,000, bought himself a new truck, and took off and left his 2 sisters in the lurch. He did nothing illegal. He is not obliged to share that with anybody if he is a beneficiary designated on the account. It also includes personal property. So the jewelry and so forth, or the art collection that you're talking about is included. And it includes any tenancy in common. And let me go on an excursion there for just a minute. Most of us who are married own our house with our spouse as joint tenants with right of survivorship. And that means when the first spouse passes, that the survivor will take title to the house because the survivor is a surviving joint tenant. And the only thing that has to be done essentially is to file the death certificate. However, way back in 2000 or so, when the tax scheme was a lot different than it is today, people were counseled to change their ownership of their house to a tenancy in common. And I don't need to go into why that is sometimes a tax planning device, but it is. But they forgot that they did that. And it means that when dad passes away, if it's in tenancy in common, unfortunately, you're going to have to open a probate for him to transfer that tenancy into the surviving spouse's name. So nearly all of us hold everything in joint tenancy with our spouse, and therefore there is no need for probate when the first spouse passes away. Having a tenancy in common can change all of that. Okay, the second thing is we don't want the tax collector to take our estate. This shows how much money you need today before your estate's going to be taxed. So if there's anybody out there within my hearing that has $11,700,000 or $23.4 million, if we're talking about a married couple, call me right after this session because we have to do some talking. But on the good chance that none of us have that much money, there is in Colorado no estate tax. It's governed by federal law. Now, many states do have an inheritance or transfer tax. And I'll give you an example. Many of you may have or may remember the New Hampshire license plate, live free or die. And I always thought that there should be an addendum to that license plate because New Hampshire does not have an income tax, but they do have a punitive inheritance and transfer tax. And so, whereas Colorado has none. So it should say live free, but if you start to feel chest pains, head for Colorado right away, because it can be a significant amount. But when you hear people say you need a living trust or you need this or that vehicle to avoid taxes, it's deceptive because in Colorado, at least as of today, there is no estate or inheritance tax. And unless you have $11.7 million, there is no federal estate tax. But wait, it may be back. these are the death tax proposals that are presently part of this omnibus $3.4 trillion bill that is pending in Congress. The first would reduce the applicable exclusion amount from 11.7 to $3.5 million. Now, again, for most of us, $3.5 million isn't going to cut it, but nevertheless, it's a significant reduction. And second, and this is very important, it would reinstate capital gains on appreciated assets. Again, I don't want to go too deeply into taxes, other than to say, when mom and dad pass away, and let's say with the price of real estate these days, that their house is worth $800,000. And let's say they bought it in 1965 for $35,000. There is an appreciation of over $700,000. And that capital gain would be taxable upon the sale by your beneficiaries, by your heirs. And then there's some additional add-on punitive taxes. So if this passes, suddenly there's a whole new dimension to estate planning, which is to avoid capital gains. For right now, the way the law is today, there is no capital gain, and your heirs will take a step up in basis. So if mom and dad's house is worth $800,000 at mom's death, that is the tax basis which the heirs will take it on. I also want to emphasize this for everybody. And this actually, believe it or not, sort of ties into the keeping lawyers out of your estate. Can't tell you how many families have approached me at one time or another and said, you know, our oldest, Steve, gosh, he's been a real disappointment. He's alienated from the family. He's gone through a number of wives. He's been on America's Most Wanted twice. We really want to cut him out of the will and let the other 3 children have our estate. And the first thing I have to say is you can do that. You can cut anybody you want out of your will other than your spouse, and I'll get to that later. But what I will say is this. In my 40 years or so of experience in doing this, if you use your will as an instrument of retribution, vengeance, if you will, on one or more of your children who have been a disappointment, maybe, the one thing I can guarantee you is that the ones that will pay for that will be your other children, because Steve is going to take it out on them. And whatever small hope that there might have been for reconciliation is going to go away. And now the kids are going to talk to each other, if at all, through lawyers for the rest of their lives. Amen. There's not going to be Thanksgiving dinners or 4th of July family reunion picnics or anything like that. And in the main, when I have actually talked to the other children, if you will, they will beg mom and dad not to do that for that very same reason. Because however narrow the opportunity for a family to heal and come back together, cutting out one of your kids is not the good way to do it. Another good thing about this is you want your family to come together at your death and not to blows. One reason for a personal property memorandum. But believe it or not, it can extend to things like funeral and burial arrangements, what services you want or don't want, organ donations, and so forth. It used to be under the law that your body and what happened to it was considered just like any other chattel, which is tangible personal property, and your personal representative did with it whatever your personal representative wanted to. Now in Colorado, your funeral and burial arrangements and organ donations can be included as part of your estate planning documents, and it is enforceable. So some people want to be cremated and their children are very, very reluctant to do that. It is enforceable if you do it that way. And as an aside, my parents died 2 weeks apart. Dad knelt at Mom's casket and said, "Take me with you." And it fell to me to look after Mom's arrangements, and because Dad was not in a position to do that, and that included a viewing, and that included picking out a dress for her. And the last thing that your personal representative wants to hear from his sibling is, "What were you thinking when you put Mom in that dress? What's wrong with you?" That sounds trivial. It sounds like a big deal, but I will tell you, when Mom and Dad pass, suddenly little things like that can mean a whole lot. And so the more that you can communicate your wishes with your family, the better, because they need to be confident that they know what you want to do. There's also an opportunity in estate planning for creating recreational property trust. I've been doing a number of these recently. People have mountain property, fishing cabins, condos, and so forth, that they want all of the family to share in. And so you can create a trust which enables this property to be enjoyed by your family and your descendants for some time. There's also a special need trust. Now, we're going to talk in a minute about trust, but a special needs trust can be created in your will. It's called a testamentary trust. If you have a beneficiary who, if they inherit something, they will lose their qualification to be a Medicaid or other public assistance recipient. And one way to make sure that doesn't happen is with a special needs trust, so that the portion of the share that that person would get is put into the trust and it doesn't disqualify them. And it's also, and this is very important, a good way to handle blended families. Some of you may be military and may think, well, I can go to the base legal office and I can get a will done there. You can, but it's that will is going to say what most of them say, and that is everything to my spouse if she survives me, and if she does not survive me, then to my children in equal shares. The difficulty arises where you have a blended family, where she may have some children and he may have some children, and maybe they have you have some children between the two of them. And if you say everything to my spouse and then to the children, if the first to die leaves everything to the surviving spouse, and then that spouse can cut out the children of the first to die. So there is a way to handle that in the wills to make sure that the children of the first to die are not cut out of the estate plan. But a will is necessary to do that. So it always matters. No will means that state law will decide who gets your estate. And that may or may not conform with what you want to do. There is a legal presumption that your spouse will be a principal, but not an exclusive heir. And as I said, there is no requirement that you include anybody in your estate except your spouse. If you purport to cut off your spouse entirely, that means that your spouse can do what's called an elective share, saying I'm entitled to 50% of this no matter what, and then a family allowance, an exempt property allowance, which totals $70,000. When somebody does this, attempts to cut off a spouse, that's when your lawyers get involved, because that is almost certainly going to involve litigation. And litigation is the enemy of probate and an easy transfer of your wealth. You can find that children from a previous marriage may take from your estate, and you maybe don't want them to take, but they might under Colorado law. You can, and I have had this situation happen, you can find suddenly that your stepchildren are your co-tenants in your house. And that's never a good situation. And that personal property memorandum that I was talking about is not enforceable. For those of you with minor children, guardianship of those children will be determined by the state and by the courts in Colorado, whereas with the will, you can nominate who you want to be your guardian. And remember this, that non-probate beneficiary designations always trump the will. So anything that you have that is being controlled by a beneficiary designation, it doesn't count against that person's share in your will. And you also, if you do nothing else, you can establish who's going to be your alternate personal representative, and that will keep your estate out of court, potentially, even if you don't have a will. And it's almost always going to be more expensive without a will than with a will. Okay, people now ask me, what about a trust? And one of my first cautions to all of you is, when you see some of the nationwide, if you will, financial advisors or what have you, saying you've got to have a trust because you've got to avoid probate. In many, if not most states, that is true. But in Colorado, I am not exaggerating, particularly here in El Paso County. I'm not exaggerating when I say I can get your will probated in less time than it takes for you to get a death certificate, which is usually 2 weeks or so. And you need a death certificate to change joint tenancy. Probate is a creature of state law. Colorado has the fastest, least expensive, most informal, user-friendly probate in Colorado. If somebody comes into my office today with an original will, it is nothing more than lodging the original will downtown at the El Paso County Probate Registrar, which is on Tejon, and filing about 4 documents electronically with the court, something I can do right here from my computer. And within a week to 10 days, that will be probated. Done. The personal representative will get something called letters testamentary, which is the authority. It means that the will has been admitted to probate, it's been accepted by the court, and it means that the personal representative or executor has been appointed by the court and can now go about basically administering the estate. Another thing that you're told is, well, it's, it's private. If you have a trust, it's private. Not in Colorado. Well, I say not in Colorado. In Colorado, this informal probate system that I'm telling you about is a closed system. It is not open to just anybody to find out what's in your will or anything like that. The only ones that are going to find out are the people that should find out, and that's your beneficiaries. So the privacy thing is kind of a red herring. Save money, save taxes, and so forth. In California, I just did this research. Probate attorneys get by law 4% of the first $100,000, 3% of the second, and so on until you get up to 1% at over $1 million. But it means that for a $200,000 estate, we're talking $30,000 or so, which is a lot. Typically, here in Colorado, probate, and I will use my example, I usually ask for a $2,000 retainer, and I more often than not end up giving some of that back because I don't earn it all. Most attorneys in Colorado don't get a percentage of the probate estate. They just charge you for how much time it takes. And as I just described to you, it doesn't take that much time. So the idea that a trust is something you must have in California, absolutely. In many states with inheritance or with where lawyers are allowed a percentage of the estate, you do want to avoid probate. In Colorado, as I said, you can get your estate probated or in less time than it takes to get a death certificate, which is what you need for a trust. There are reasons for a living trust in Colorado, and two of them come to mind. One is if you have real estate in other states. States are very jealous about the dirt that's located inside their borders. And so if you have real property in Kansas or Missouri or Texas or California, God forbid, you're going to have to go into that estate, into that state, and do their probate in order to transfer that property. And that will make it subject to transfer and inheritance taxes in the other states as well. So if you have property in other states, it's worth considering a living trust and putting that property into a living trust so that you may avoid probate in that state. And the second one is, I think, the most compelling reason for a living trust in Colorado. And that's if you have a family member who is suffering or is approaching suffering from a disability such that they will be incapacitated. I can't tell you how many times my heart has been broken because mom or dad has Alzheimer's pretty bad, and nobody knows. The children are out of state. They call on the phone. She's able to kind of pull it off on the phone that everything is okay. Dad is not going to tell anybody, but then something happens to dad, and mom is utterly helpless. And potentially victimized by predators if dad dies. Had a case where we were working on a trust for somebody where mom was already kind of well on the road to incapacity and Alzheimer's. And I got a call from the Teller County coroner that they had gone in on a wellness check and discovered that he had been dead for 4 to 6 weeks and was still in the house, his body. And his wife was still there. With a living trust, there would have been no need, as there was in this case, for emergency hearing at night in court to try to get her taken care of. So it's a really good way for a family to plan for incapacity. Okay, ticket number 2, the general durable springing power of attorney. Let me break that down. This is what's called a general power of attorney. The way to think of it is as this is your power of attorney that you use for your money, for your banking and checking and investments and payments and so forth. Way back in WWNOM, when they sent us overseas, you'd go to the JAG office and you would get, just kind of a rubber stamp general power of attorney that would be given to your spouse. And unfortunately, I actually had a friend where this happened to. With that general power of attorney, the spouse was able to divorce him in absentia and to sock him with support and child support payments that were, to say the least, excessive. And so that's not the way to do it. And so that's where springing comes into effect. The way a good power of attorney is phrased, it only comes into effect at your incapacity. So the power of attorney, your agent under power of attorney, must prove that you are incapacitated. Then also make it durable. In the old days, at common law, an agent could only do what the principal could do. And that meant if the principal was incapacitated, suffering from dementia, that the agent couldn't act. So durable means that it survives your incapacity. So a general durable springing power of attorney is a power of attorney that enables somebody that you appoint to take over your finances only when you are incapacitated. And then it does survive your incapacity. This is a great way to do long-term care planning and to plan for disability or incapacity. Because with a power of attorney, even if the surviving spouse or family member is still living and is incapacitated, the power of attorney can step up and make sure that he is not exploited. And you can also designate your guardian or your conservator. And that's the way that you, I'm sorry for this, I thought this was off. When you don't have a power of attorney, and I'm going to get to the medical power of attorney in just a jiffy, and something happens to you, you suffer a stroke or whatever, and you are incapacitated, if you don't have a power of attorney, the court is going to designate a guardian for you. And a guardian is just what the name implies, somebody who's responsible for your body. And then it's also, if you have money, designate a conservator who is going to manage your money for you. In your power of attorney, you can say, I don't want that. I think my power of attorney should be enough, but if I end up in court, these are the people I want to be taking care of me. This is the person I want as a guardian, and this is the person I want as a conservator. So you'll have a voice. So why is it a good idea to have this general durable springing power of attorney? Well, one thing is, let's suppose that it's time to downsize and you need to sell the house and you'd like capacity. This is a way to make sure that you're still able to transfer the real estate. You can still do your state and federal tax filing. It's a good way to provide for Medicaid tax planning. Now, this is the subject for a whole different talk, but qualification for Medicaid can sometimes be had by something called a Miller Income Trust, and you can also purchase community spouse annuities. And again, way beyond the scope of what we're doing here, but with a power of attorney, these kinds of things can be done if they are appropriate. And also contracting for long-term care. And I mentioned downsizing. And gifting the family, unless you have over $11.7 million, there's no particular reason to do that with a power of attorney. Real quick, there are some of you who have veterans in the family, many of you perhaps, and that person needs to go into skilled care or assisted living, what have you, and suddenly there's somebody pressing you and telling you, you know, you can get $2,000 a month with VA aid and attendance, and it's tax-free, and you can keep Medicaid, and it will shelter your assets from creditors and state. This is only partially true because it sounds too good to be true, and it generally speaking is. When somebody offers to do this for you, what they are going to do is to have you put all of your assets, and I mean all of them, into an irrevocable living trust. Irrevocable meaning just what the name implies, it's gone for good. Then they're going to take and sell all of your assets like your house and so forth, and they're going to buy very expensive front-end load annuities with them that they get a great deal of money from. But most important, if you do this, if you transfer assets out of your estate and you need Medicaid assistance for long-term care within the next 5 years, it will disqualify you from doing that. Now, I'm not telling you that VA aid and attendance is not appropriate in the right circumstances. What I am telling you is, if you get this pitch, please see a competent attorney who knows how to do these sort of things, not one nominated by the salesman, and find out if it is right for you. Okay, ticket number 3, the medical durable power of attorney. This is kind of the reciprocal of the financial power of attorney, and this appoints somebody for medical decisions. It is a great disability and long-term care planning tool. As it stands right now, with the law the way it is, if your husband or wife is hit by a bus and is face down in Memorial Hospital on a gurney and unconscious, and you go and say, "How is my darling wife?" They won't tell you she's even there without a medical power of attorney. Even though you may have been married for 50 years, the medical power of attorney is essential in order to get past all of the privacy regulations that constrain hospitals. So HIPAA is sometimes not your friend in that regard. It gives you the opportunity to do end-of-life planning. I'm going to get to the fourth tool in a minute, but it's bigger than that. The medical power of attorney is not just end of life. It's where you have a stroke and the person with your power of attorney is going to be able to see to your care, make decisions with respect to surgery and procedures and so forth. And if rehabilitation or other kind of placement is necessary, the person with your power of attorney will have the authority to do that. Again, you can avoid a court-ordered guardianship because without something like this and you're incapacitated, your family is going to have to go to court to get a guardian appointed. And so that is not an inexpensive procedure. It's not a quick procedure. Typically, it's $3,000 to $5,000, and it's at least 60 days before you can get somebody appointed as a guardian. And remembering this, regardless of your power of attorney, you are the boss of you as long as you can communicate with your physician or care provider. The physician, I don't care if you're actually blinking a message to somebody, doesn't matter what your power of attorney says, as long as you can talk, you are in charge of what is done for you and what is not. Okay, the last ticket is the living will. Living will is something that tells your doctors what you want done and what you don't want done in an end-of-life situation. Typically, at least the ones that I draft, have kind of 4 qualifications. 1, I'm unconscious, in a coma, or otherwise unable to make or communicate my decisions. 2, I suffer from a terminal disease or condition. 3, my healthcare provider and one other provider certify the first 2 in writing. And 4, I have been in that circumstance for some period of time, usually 7 days or longer. Here is why it's important. It is not a do not resuscitate order, not a DNR. This thing just defines very specifically the point at which you may wish to have life-saving procedures or life-prolonging procedures continued. The way I do it is I want to make sure that your family is in the loop. I do not want a situation where 7 days has come and gone, the second hand sweeps across the 12 to end the 7th day, and the doctors pull the plug on you. And by pulling the plug, typically what we mean is the withdrawal of nourishment and hydration. And what this means in practical terms is that the likelihood is that you will die from want of water or food or both. And that, of course, has a lot of significance to many people. So the way that I do it is I always make sure in this order that your loved one, your family, your medical power of attorney is in the decision loop. And I'll give you an example of what I'm talking about. I had a situation of a living will that I did for a woman years gone by. And she had just one child, a daughter. And she suffered from a massive stroke. And within, she was in a coma, period. So she was in intensive care. She was in a coma. 7 days came and went. And the doctors approached her daughter and said, we think that this advanced medical directive, that the criteria have all been met, and maybe it's time to let mom go. But we need your permission to do that. And daughter said, last night, I was with my mom, as I've been every night with her, and I was talking with her and I was stroking her arm, and she squeezed my hand. She squeezed my hand again. I think mom might come out of this. So let's wait. Well, mom did come out of this, and I'm not talking about a twilight half existence or anything like that. She fully recovered her faculties and she lived for another year and a half. So the living will needs to be flexible. It needs to express your intentions and your beliefs and your values. And in my opinion, it needs to have somebody from your family who knows those opinions and values to be the final say-so. Okay, appointing fiduciaries. I'm going to kind of zip through this. But in the process of doing these estate planning documents, you are going to be nominating a personal representative and maybe a backup personal representative. You're going to be nominating somebody for your medical power of attorney and usually a backup, and somebody for your financial power and a backup and so forth. These people are entrusted with your life and your health and your wealth all at the same time. And so it's important to pick the right person. Sometimes families say, well, you know, I probably should appoint the oldest child because as my backup, because typically husband and wife are each other's primary. Maybe I should do the oldest child because, well, you know, he's the oldest. Here's my advice on your fiduciaries. Pick the person, obviously, who you trust. I mean, that is the most important thing. But the second one is not who is the oldest, not who is in town or not in town. It is the one that gets along best with his or her siblings. That is the key. You don't need a lawyer to do the probate just because you have a kid who's a lawyer. I'm sorry for you if you do, but I mean, some of you do. You don't need to have your kid who is a doctor be the medical power of attorney. You want the one who, when you close your eyes and a decision is posed, what nursing home am I going to? What kind of rehabilitation do I want? What kind of treatment? You close your eyes and say, who do I want answering that question? And that's the right choice because, as I said, they are going to need a lot of information about you that's very, very, very important and personal. I use the example of the tree falling in the forest, you know, and what happens if nobody can hear it. What if you have this perfect estate plan and you have all four of those tickets, but nobody knows where it is? You might as well not have it. So you want to make sure that your original will is in a place where obviously it's safe, where it won't be consumed in the same fire with you, and where your alternate personal representative knows where it is and has access to it. Some people say, well, how about a safety deposit box? That's fine. That's perfectly okay. But make sure that the bank knows that your will's in there, that your alternate personal representative knows that your will is in there, and knows and that, excuse me, that your alternate personal representative has access to that safety deposit box, meaning usually a key. The smart book that I'm talking about has all of this information. Here's where my documents are. And when I do estate planning, I provide this to everybody. Make sure that if a spouse is disabled and maybe incapacitated cognitively, that the family knows about it. Don't have that terrible situation that I experienced a couple of months ago. You need to be frank with the kids to say that, you know, mom is starting to have some pretty significant memory issues. And you all need to know that you need to step in quickly if something happens to me. And have this information. Having a will and power of attorney, giving somebody the ability to pay off the bills, because Morgan's law is that Murphy was an optimist and that the day that you suffer that stroke is the day the hot water heater will explode and flood the basement. So you want your fiduciaries to have bank account numbers, to have investment account numbers, to have numbers of CDs and user ID and passwords. Because more and more of us do our transactions in our banking online. And if your fiduciary doesn't know how to get into your account, they might as well not have the power. Make sure that your family knows who your primary care physician is, who your lawyer is, who your dentist is, who the dog's veterinarian is. All of those things are really important. And it doesn't do any good if it's up there in the back of your mind, because by definition, you're not in a position to do anything. And then I talked about a safety deposit box. Make sure that if you have life insurance policies, that your family knows about them. Make sure that they're kept up to date, that the policies themselves are available. When somebody passes away, believe it or not, Aetna doesn't scan the obituaries and say, Morgan, oh yeah, let's call up his widow and tell her she just hit the lotto because he's got a huge policy with us. Insurance companies are not proactive that way. They need to be contacted. In order for them to be contacted, somebody needs to know about them. And we're right at 5 o'clock. So bonus tip, I'd be happy to entertain your questions. And I'm not sure how we want to handle it.
We have one question in the chat, and then we have another question that was emailed earlier prior to the presentation. This first chat question is stated: if we have all of these things, the 4 tickets done in Colorado, are they just as valid in another state? Should they be revisited upon becoming a resident in another state?
That's a great question. Because of the full faith and credit portion of the Constitution, they will be honored in another state. Now, the fact that they will be honored in another state doesn't mean that they're going to be appropriate for you. As I discussed, in Colorado, there's really not much reason for a living trust to have all of your assets in. In California, it would be malpractice not to have them in a living trust. So you would want to go to a local attorney and have them look at the will and decide whether or not the things that you're trying to do are still appropriate, or if there are some planning tools that you need to accommodate the new state.
Okay, if that answered your question, then that's great. And if not, just put another question in the chat, or you can unmute yourself if you would like. What I'd like to do is—
I have a second one here that says, is it better to have my daughter on my N account, or should I have her as POA on the account? My point exactly. If you have, there is no reason to have your daughter as POA, excuse me, as a signatory on your N account. Now, you can tell Aunt that she has power of attorney, and you can give them a copy of that power of attorney, which means that if something happens to you, she can simply sign the checks as power of attorney with her own name. But you do not want to give her ownership of the account unless she's an only child, in which case there's no reason not to. There's no reason to have a will if there is just one child.
Okay, we had an email that I'm going to go ahead and read to you. Do you advocate the use of trusts over wills? Follow-up question would be why or why not? Could they be used in tandem? If yes, what types of items would be better suited to going in a trust, and which would be better in a will?
I think I answered that in the course of the presentation. In Colorado, there is really no reason to have a living trust because it will do nothing that a will won't do faster and less expensively. There are specific situations where you may want a trust, but there is nothing that a trust can do in Colorado that a will can't. And typically a trust is going to cost you $5,000 or so. And that's less money than typically probate even costs in Colorado.
Wow. Can you share, designate both sons as backup power of attorney and so on? Spouse is primary?
Can you? Yes. I recommend strongly against having more than 2 fiduciaries. Certainly you can have one or the other of the sons as a backup. But when you have 2 of them, many banks and institutions require that everything that is done has to be signed by both of them. And inevitably, the case, one of the sons is going to be in Nairobi at the time, and you can't get the signature. So it is better to have one of them. And if you want to have the other one as backup, you can do that as well. But I do not recommend co-fiduciaries. Because if they don't agree, guess where that gets settled?
Would you mind reviewing the question? She said, is it better to have my daughter on my account or should I have her as POA on the account? And then at the end of your explanation, you said if there's only one son or daughter, that yes, it would make sense. Could you repeat that? That's
Sure.
for my benefit. Yeah.
Recall that I said that a payable on death designation or a joint owner, your account is going to transfer to that person at your death. If you have more than one child and your will says to my children in equal shares, the account that transfers on death is not going to be accounted against that child's share. So if you have a $100,000 account and you have a $500,000 estate, that $100,000 is going to go to that child, and then the remainder of it will be divided equally among all of the children, with the payable on death account not counting against the share. So you end up with one child getting sometimes significantly more than the others, and you did not intend that. Now, if you have just one child, then no problem with payable on death and transfer on death designations, no problem at all. And if you have a house for that one child, there is a trick called a beneficiary deed, which you can basically deed the house over to that child and there will be no probate. So with one child, things take on a different dimension. With more than one beneficiary under your will, then none of those things are good ideas.
Okay, thank you. Another question, is there any problem listing both / all children as POD on bank accounts?
Yes. I recommend against that because they take automatically in whatever shares you have on your bank accounts, and you can end up with no liquidity for your estate. So there's no money to put the house up for sale. There's no money for a fix up. There's no money to pay for funeral expenses, expenses of the last illness or anything. It is no faster to put them POD than it is in Colorado than to simply just keep it in your own name. And I strongly recommend that that's what you do. If it sounds like I'm against POD, it's because I have seen very well-meaning parents who have a very carefully crafted estate plan dividing their estate among the 4 or 5 children. And then they put all these CDs on as POD, and it ends up that the math doesn't work out. And one or the other children suffer as a result.
Pamela, can I ask a question ongoing
Sure.
with that?
Sure.
What about, my concern is if I'm all alone, and if I am in the hospital and my children need to take care of things for me because I'm incapacitated, how do I do that with the POA and give that to my credit union?
Yes, ma'am. That's exactly how you do it.
Okay.
You sit the kids down and then you decide, somebody's going to need to take care of my finances. Somebody's going to need to make decisions for me if something happens to me. And then you can discuss, who's the right one to do it. And it may be the same child does both of those things. But if you're all alone and something happens to you and you don't have these, you're going to find yourself in court.
Did that answer your question, Joan? Okay, okay.
Thank you. And hello, I wanted to say hello to Barbara Winters.
Okay,
Thank you very much.
so Skip, is there any special guidance around single individuals, older adults who do not have a family member? Perhaps they don't have close friends even. And they're in a bit of a quandary as to how to put those documents together because they really have no one to refer to. Do you have any suggestions around that?
Yes. And that is in our day and age, an increasingly common situation where people simply outlive their family, or maybe they just don't have any family. You have one of several choices. Most of us have good or dear friends that we trust. And that's who I would go to first. I mean, obviously you need to discuss that with them, but you may have people from your church or your community or your club or what have you that you really trust. And you can say, look, I really don't have any family members. I don't want to the court, because if you go to court, and you don't have anybody, there's going to be, the state's going to appoint somebody to do that. And that's going to be somebody almost undoubtedly you don't know. If you don't have somebody like that, there are professional fiduciaries. And professional means, yeah, they get paid. But if you have an attorney who's kind of familiar with the atmosphere and the environment, then there are professional fiduciaries who will do this and who can be trusted.
Okay, thank you. We have another question in the chat. My husband and I set up a trust and a will a long time ago. Now that he is gone, the will needs to be changed because some of his children have passed away and it is no longer relevant. I was never informed of a personal property memorandum, which sounds great. I would like to be able to write a will when I am ready and just let the trust stand alone.
Yeah, here's the thing about a trust. In order to, every trust that is drafted is going to have something called a pour over will. And the gist of it is this: everything that I have at my death that is not in the trust, put in the trust, because the trust decides where everything goes. And so if you will look at your trust, you will see there will be what's called a pour over will. I may not say that, but the gist of it will be everything goes into my trust, my death. The reason that's necessary is that most of us are going to end up passing away, even with the living trust, and we're going to have property that isn't in that living trust. When you do that, you have just defeated the only remaining purpose of the trust, because you are going to have to probate a will in order to take that property that wasn't in the trust and put it in the trust. So I obviously can't speak to the specifics of your trust in this case, but I would say that it is likely that you will probably want to start over and not end up with a really awkward situation. I had a case recently where in another state, for reasons that I can never understand, both husband and wife had their individual trust. And so there were two trusts, and those two trusts owned their house. So in effect, you have two trusts that own, and there are tenants in common. And that would have meant that if one of them passed away, in order to pass the property to the other, the will would have to be probated. And then that portion of the estate, or rather of the house, needed to be actually transferred with a personal representative's deed into the other trust. It would have been doable. It would have massively multiplied the complication and the difficulty for when the first spouse passed away. So as a rule, when somebody has a trust, I will look at it and see if it is still doing you any good. And if it's not, then get rid of it.
So should I dissolve the trust?
I have to look at it without knowing.
Okay. Do we have any other questions? You can unmute yourself or you can type it in the chat. Skip has covered a lot of material today, and it may take some time to digest it all, but do you have contact information for them, Skip? If they wanted to
I think it was on the
follow up?
first page of the presentation. I don't know whether people got that or what,
Okay,
but obviously with the Zoom, it's, if you look at the, let me go back to the,
okay, that was on your first slide. Excellent. Okay. So there is your contact information, and all of this is also recorded. It will be on our website as well. If you wanted to go back and listen to this again, you're always welcome to do that. So a reminder about the survey that you all will be getting tomorrow morning. Please fill that out, be very candid. Give us suggestions for more information or less information, or things that topics that we haven't discussed, whether it's Skip's presentation or any other presentation. And then, of course, if you want to be in the drawing, please put your email there so you can be entered into the drawing for the gift card that Ed will be taking care of. We have 2 more presentations, which I think I mentioned to you. We've got the Social Security webinar coming up, and then we have another webinar on meaning and purpose. Those will be coming up next week. The last session will be October 4th on Monday. So we welcome you to join those, to investigate and see if that's something you would like to take advantage of. We also have other webinars on our PPACG site, ppacg.org/events. Unless I hear anything else at this time, we're going to go ahead and call it. And we appreciate everybody being here this evening. Thank you so much for joining us. Skip, thank you so much again
you're welcome.
for helping us out and doing a great presentation. All right. Good night, folks. Everybody have a good evening. Thank you.